We now approach the end of this trial. Soon you will retire to your jury room, and there you will endeavor to arrive at a verdict that will be fair to all the parties in this case on the basis of the evidence adduced here and the applicable principles of law which I shall lay down to you. The plaintiffs bring this action to recover damages for personal injuries which they allege were sustained by reason of the negligence of both defendants. In order to recover a verdict, the plaintiff must prove that it was the negligence of the defendants which was the proximate cause of the accident. Negligence may be defined as the failure or the omission to do some act or perform some duty which one person owes to another. More simply defined, it is the absence of such care as a reasonably prudent person would be expected to use under the same or similar circumstances. I am not going to review the evidence in too great detail. You have heard the testimony offered on behalf of the plaintiffs and on behalf of the defendants, and the law places upon you exclusively and not upon the court the burden of deciding the issues of fact based upon your recollection of the testimony and not upon any statement that I might give you. And yet, because of the inordinate length of the trial and the intervening weekend, I think that I should touch briefly upon the evidence which has been developed before you. Suffice it to say that the plaintiffs claim that at the time of the accident they were being transported in an open truck by the defendant, William Peters. That while they were proceeding west through what is known as the Transverse Road, which is a public highway under the control of the City of New York, a scaffold resting on the truck and on which the plaintiffs were sitting came in contact with an overhanging branch of a tree, as a result of which they were thrown from the scaffold to the roadway, and they were caused to sustain the injuries which they testified to, and which are reflected by the testimony of their directors and the hospital records in evidence. Plaintiff Smith and other witnesses told you how the truck was loaded. It appears that it contained steam machines, barrels, and buckets. It carried 2 scaffolds. One of them had been stripped and placed on the right side of the truck. The other was assembled and placed on top of and resting on the oil drums in the manner testified to. The driver had placed a red flag at the end of the scaffold protruding from the rear of the truck. The testimony of the foreman working for the Daniel Corporation, the other defendant, also the employer of the plaintiffs, was to the effect that it was the driver's job to place the things on the truck where he thought they belonged. Plaintiff Smith, according to his testimony, was sitting on the scaffold looking toward the right side of the truck. With the left hand, he held what he described as the back center iron of the scaffold. The other plaintiff, George, sat to his left facing in the same direction. Across from them were their 2 fellow employees, who were sitting in the spaces between the machines on the left side of the truck. The truck was being driven by an employee of the defendant, Peters, who had been referred to as Andy. He was seated in the cab, and alongside of him, as they proceeded, was the foreman, the same corporation which employed the plaintiff. As to the accident itself, the plaintiffs could tell us no more than the fact that as they left the underpass and were proceeding west, they heard a crash which tipped the scaffold over. Smith said it was a fast, sudden tip, and that they were thrown to the street. George testified he did not notice what caused the accident. The foreman, who was sitting alongside of Andy, the driver of the truck, testified that he heard a commotion. To use his words, bushes were cracking, and in front of him was what he described as a pile of branches coming off the scaffold like his testimony was that a branch of the tree hanging over the roadway caught the scaffold on the truck, and that he saw the two men fall from the scaffold into the street. We have the testimony of the bus driver, who testified he was driving a bus through the transverse in the time of the accident, and that there was a private car between the bus and the truck which was involved in the accident. He told you he had seen the limb in the tree in question about 5 to 6 weeks before the accident. And he also told you that he was close to the center white line between twigs that were scraping the top of the bus. For the city of New York, we have the testimony of the gardener who identified the branch and the tree from which it came. He stated that they always had heavy traffic on this road, with buses, high trailer trucks, and moving vans going through, but there had never been any accident like the one in consideration here. This is a rather brief view or review of the testimony. (180)